Hello, welcome to our forum on how to choose a Wisconsin Supreme Court Justice, hosted and organized by the League of Women Voters of Dane County. I am your moderator, Marilyn Townsend. We will begin with a land acknowledgement statement by Katrina Willis.
League formation began more than a century ago, in 1920, with women's suffrage, but nearly 2 centuries ago, even prior to the 1848 creation of the state of Wisconsin, an 1832 treaty forced the Ho-Chunk to cede their territory of Dejo, 4 lakes. Both the federal and state governments repeatedly but unsuccessfully sought to forcibly remove the Ho-Chunk from Wisconsin. Truth and acknowledgement are critical to building mutual respect and connections across all areas of heritage and difference. We continue this effort to acknowledge what has been buried by honoring the truth. In Dane County, we are all standing on the stolen ancestral lands of the Ho-Chunk people. We pay respect to their elders, past, present, and future. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that brings us together today. LWVDC is grateful for the past, present, and future guidance of Wisconsin's Native nations. Thank you.
Again, welcome to our forum on how to choose a Wisconsin Supreme Court Justice, organized and presented by the League of Women Voters of Dane County. For those attendees who may not be familiar with the League of Women Voters, allow me a brief introduction to the League before introducing tonight's presenters. The League of Women Voters is a nonpartisan grassroots organization working to protect and expand voting rights and to ensure everyone is represented in our democracy. The League works to educate voters through avenues such as today's webinar. The Dane County League website at lwvdanecounty.org contains announcements and information important to voters, including how to find which races will be on the February 18th spring primary ballot in your community and which races will be on the Tuesday, April 1st spring election ballot. To find out, just go to the League website and click vote411.org and enter your address. In order to assist voters, the Dane County League of Women Voters also conducts video interviews of candidates in local primary and general election races. Voters can currently watch video interviews for Madison City Council races with a primary by going to the League website and clicking Know Your Candidates. After the primary election and in preparation for voting on April 1st, voters can access the same location to watch video interviews of candidates for local school board, alder, and county executive here in Dane County. Looking ahead, following tonight's webinar, the League will present another webinar on March 6th, this time on responsible gun laws and policies for Wisconsin. And on Saturday, April 26th, you are invited to attend a luncheon in Madison where the speaker will address civic health in Wisconsin. The League also organizes book discussions on February 27th and March 1st. The featured book will be One Nation Under Guns. For those interested, the League has many volunteer opportunities, which include moderating this forum as I'm doing this evening. Please go to the League website for further information. Again, welcome to our forum on how to choose a Wisconsin Supreme Court Justice, hosted and organized, as I said, by the League of Women Voters of Dane County. Our esteemed panelists tonight are law professor Robert Yablon, who will provide an overview of the qualifications for an ideal Wisconsin Supreme Court justice. Retired Judge Paul Higginbotham will discuss how campaign finance has influenced those who run for the Supreme Court. And Jeff Mandel, General Counsel of Law Forward, will preview the cases likely to be heard by the court, depending on who is elected at the election on April 1st and what the implications of those cases may be. As I stated, I am your moderator, Marilyn Townsend. I am an attorney who serves as a commissioner on the Labor and Industry Review Commission, where with two other commissioners, I decide appeals involving workers' compensation, unemployment, and discrimination claims. Prior to my current position, I operated my own law firm for over 30 years and also served for 6 years as a municipal court judge. Our first speaker today on how to choose a Wisconsin Supreme Court Justice is Robert Yablon, who is a professor of law at the University of Wisconsin Law School, where he teaches courses on the law of democracy, civil procedure, and federal jurisdiction. He also serves as the faculty co-director of the State Democracy Research Initiative, which seeks to advance research and dialogue on state-level democracy, government institutions, and public law across the nation. Professor Yablon graduated from the University of Wisconsin and Yale Law School, where he was an articles editor of the Yale Law Journal. He served as a law clerk for United States Supreme Court Justices Ruth Bader Ginsburg and Sonia Sotomayor. I present to you Professor Yablon.
Thank you, Marilyn, for that introduction, and thank you so much to everyone who is joining this evening. So I was asked to speak a little bit about the characteristics of a judge, the qualifications for a judge, and I have some specific prompts that Marilyn gave me, and I'm going to stick pretty closely to those just to make sure I am responsive. A word just at the beginning, a few basics about the Wisconsin Supreme Court itself. The court sits at the apex of the Wisconsin judicial system. Under the Wisconsin Constitution, the state Supreme Court has, quote, superintending and administrative authority, as well as appellate jurisdiction over all of the state's courts. The court has 7 members. They're elected to 10-year terms in elections that are formally nonpartisan, which means there are no partisan primaries for our state's judicial offices and no partisan affiliations are listed for judges on the ballot. The court hears just a few dozen cases every year, and it selects those cases from hundreds of cases that it's asked to hear. But even those hundreds of cases really represent just a very small fraction of the hundreds of thousands of cases that are decided in the Wisconsin court system, starting at the trial level each year. So the first prompt that I got from Marilyn was, what are some of the characteristics, some of the training and prior experience that would equip a candidate to be a judge who is able to arrive at decisions that prioritize the rule of law? And so again, just to start with some basics, there are some qualification requirements that are set forth directly in our state constitution. To be eligible to serve as a justice or as a lower court judge, a person must be an attorney licensed to practice law in this state and has to have been so licensed for 5 years immediately prior to election or appointment. So the Constitution contemplates that a judge will be an attorney and one who has at least a bit of experience. And if you think about the backgrounds of our current state Supreme Court justices, it'll give you a sense of the kinds of qualifications that justices typically have on the court. So among those justices, you have a number of individuals who previously worked as prosecutors, several who worked as prosecutors in Milwaukee County, one as a prosecutor in Dane County. You have individuals who spent time working for the state executive branch, for governors, for the State Department of Justice, and you have people who served in private practice for various lengths of time. Notably, all of the individuals who are currently serving on the Wisconsin Supreme Court first served as lower state court judges. 6 of the 7 members of the court served as state circuit court judges. Those are our primary county level state trial courts. The only one who didn't serve as a circuit court judge is Justice Hagedorn, who served as a Court of Appeals judge. And one of the members of the court, Justice Rebecca Bradley, served as both a trial level and a Court of Appeals judge. Now, that's not a necessity. I think it would be entirely possible for someone who is an experienced lawyer to step right in as a state Supreme Court justice, and there are plenty of individuals in other states who are capable Supreme Court judges who don't have that prior experience. And at the US Supreme Court level, Justice Elena Kagan most recently stepped into the role without having first served as a judge. But again, that is a bit of experience that all of our current justices share. Well, what about more broadly, some of the characteristics that we might look for in a judge? Different people will prioritize different personal characteristics. I think that it is important, given the role of a judge, someone who is presented often with complicated, legally complex cases, to be someone who has the wherewithal to take on complicated issues and really wrestle with them. Ideally, someone who's able to do that in an open-minded way. Someone who, even if they've thought about an issue before and may have some inclinations beforehand, is still willing to hear from the litigants with an open mind, and on a multi-member court like the Wisconsin Supreme Court is willing to listen respectfully to their colleagues as well. And so, there are other characteristics that may be associated with that, characteristics like humility, characteristics like integrity. One other one that I will highlight is independence. The judicial branch is an independent branch of our state government. It is one of its roles is to check the legislative and executive branches. And so, especially in a polarized time, it might be appropriate to think about who is a judge or justice who will not just be a rubber stamp for particular political actors or interests, someone who really is willing to take seriously that role of being a check on the other branches. And another way to put that is someone who is willing to say no, not just to their adversaries, but who's also willing to say no in the appropriate moment to their usual friends and allies when those individuals go too far. So another question that Marilyn asked me to focus on it relates more specifically to judicial elections and campaigns. And that is, are judicial candidates allowed to express opinions on the campaign trail? And so let me offer a few words on that. The short answer to the question is yes, they are. More than 2 decades ago, the US Supreme Court held in a case called Republican Party of Minnesota versus White that judicial candidates have a First Amendment right to share their views on the campaign trail. That case involved a Minnesota judicial ethics rule that prohibited candidates from announcing their views on, quote, disputed legal or political issues. And the challengers to that rule included a candidate for judicial office who was putting out literature criticizing prior decisions of the Minnesota Supreme Court on issues like crime and welfare and abortion. And the challengers also included the state Republican Party, who argued that this ethics rule prevented the party and its supporters from learning information that they would want to know about judicial candidates. Now, the state of Minnesota defended its rule as a way to preserve judicial impartiality, but the US Supreme Court rejected that as an adequate justification. Justice Scalia wrote for the court that due process doesn't require judges to avoid, what due process requires is that judges avoid bias for or against parties to proceedings. But it doesn't require that judges avoid the prior expression of views on issues. In that opinion, Justice Scalia wrote, quote, "A judge's lack of predisposition regarding the relevant issues in a case has never been thought a necessary component of equal justice. And with good reason. For one thing, it is virtually impossible to find a judge who does not have preconceptions about the law." As Justice Scalia saw it, a lack of preconceptions was evidence of, quote, "a lack of qualification, not a lack of bias." Now, that doesn't mean that judges have complete free reign on the campaign trail. Under Wisconsin's Code of Judicial Conduct, a judge can go too far if on the campaign trail they make promises, pledges, or commitments with respect to particular cases or issues. And so that's the line that judicial candidates need to be aware of. It is completely fine for them to express views on issues, but they can't make promises that they will rule particular ways or for or against particular parties. Now, the next question that Marilyn asked me to address was about judicial philosophies and saying a few words about judicial philosophies that you may hear justices speak about. So when I'm talking about judicial philosophies, I really mean some of the broad principles and beliefs that shape a judge's approach to resolving legal disputes. How is it that a judge is going to approach the task of legal interpretation? Now, out in the world, when you're thinking about judicial campaigns, the most frequent philosophy labels that you're likely to hear are judges or candidates who describe themselves as originalists or perhaps as textualists. Now, these are capacious and often contested concepts, and they can come in many different flavors. Justice Elena Kagan has said, "We are all originalists. We are all textualists." And to some extent, that is right. Pretty much any judge out there, when faced with a constitutional or statutory controversy, will ground their analysis in the written text, and they will also be interested in the origins and history of that text. So when there are judges or judicial candidates out there who are self-consciously identifying themselves as originalists in particular, they're most often trying to convey a couple of things. First, they're expressing a view that when they're considering constitutional cases, they believe those cases should be resolved in accordance with the original public meaning of the Constitution's text. In other words, what would the constitutional language at issue have meant to someone at the time that it was adopted? And sometimes they'll say that this requires judges to adhere to history and tradition. Second, just as a practical matter, the judges or judicial candidates who are choosing to cast themselves as originalists are very often seeking to convey alignment with the conservative legal movement. In academia and in other places in the world, there are folks who will identify as originalists, but who will emphatically not identify as conservatives. But on the campaign trail, these philosophies tend to be in line. And so sometimes people who will identify as originalists will also describe themselves as judicial conservatives. And they're doing that in part to signal to potential supporters or funders that their views are likely to be in step with, say, the conservative supermajority that we currently have on the US Supreme Court, or with the current conservative wing of our state Supreme Court. Now, they also may be trying to convey that without taking on the baggage that might come if they were to directly to say that they support some of the less popular decisions that we've gotten from the current Supreme Court, for example, right? If you think about decisions to overturn Roe versus Wade, to expand the breadth of presidential immunity, to weaken the Voting Rights Act, to gut campaign finance laws, a lot of that is not popular, and so candidates may be reluctant to express affinity with those particular decisions, but they indirectly do so through these philosophy labels. Now, self-described originalists will sometimes contrast their approach with what they describe as living constitutionalism. There aren't that many folks who are campaigning for judicial office who tend to affirmatively embrace that label as a philosophy, although occasionally some do, and they may say, well, I'd rather have a living constitution than a dead one. So judges who don't affirmatively cast themselves as originalists may not specify exactly what philosophy they are. Impliedly, they may have simply a more pragmatic approach to law. They may view originalism as an approach that is too backward-looking or blinkered. They may be skeptical that judges who proclaim that they are originalists really are able to glean answers to particular cases from old provisions, textual provisions. History and tradition may not always offer clear guidance about contemporary disputes. And so they may believe that originalists aren't avoiding value judgments, they're just obscuring them with talk of history and tradition. And so these judges may be more candid, more wide-ranging, pragmatic, more candidly considering, say, the real-world consequences of their decisions, or what the potential will be for a decision of theirs to make our political system, say, more or less healthy or functional. Now, a final prompt that I got from Maryland was, how could a voter's Wisconsin Supreme Court justice choice affect them? Well, Jeff is going to have a lot more to say about what is potentially on the court's docket, and so I'll leave a lot of this answer to him. The bottom line is that the court hears a lot of high-stakes cases. And beyond the particular cases that they might hear, they do play, as I indicated before, an important role in steadying our system of government and checking overreach by the other branches. And so what's at stake often in a judicial election is how will that checking function actually operate? One final thing that I will note, as we enter the active period of a judicial campaign, I think that what we will all see is that a disproportionate amount of campaign rhetoric and a lot of campaign advertising and a lot of money that floods into the race will be spent trying to boost the candidates as tough on crime or to call their opponents soft on crime. And these messages are out there because I think that they strike a chord with the public. But I want to suggest that those messages convey a little bit of a mistaken impression about what is really going on and what's principally at stake when it comes to the Wisconsin Supreme Court. Members of the Wisconsin Supreme Court, as I said at the beginning, they're sitting at the apex of our judicial system. They're not directly sentencing offenders. They're not deciding who should be prosecuted. And for the most part, they are not themselves setting criminal justice policy. There are other actors in our system who are doing that. Now, of course, the court does hear from time to time criminal law cases, so I don't want to suggest that they have no role in the criminal justice process, but those tend not to be the court's biggest ticket cases. And it's notable that oftentimes the folks who are maybe spending outside money running these sorts of ads tend to have very little interest in criminal justice issues themselves. They may have other agendas, other reasons why they're favoring one candidate or another, but they think that this is a particular message that will resonate. And so I would urge all of you as the campaign unfolds to be educated consumers and approach with an appropriate degree of caution some of the messages that you're seeing. And if you're someone who is engaged enough with this to be joining us tonight, to hopefully help your friends and family also be educated and informed when it comes to some of the messaging that we're likely to see in what I expect will be a quite contentious race.
Thank you. Thank you, Professor, for that very informative presentation. We will go on to our next speaker. Judge Paul Higginbotham served almost 15 years on the Wisconsin Court of Appeals before retiring in 2017. He also served as a municipal court judge and for 9 years as a Dane County Circuit Court judge. Judge Higginbotham graduated from the University of Wisconsin at Madison and the University of Wisconsin Law School. He was an attorney with the Legal Aid Society of Milwaukee and also served as a member of the University Law School faculty. He currently serves on the Wisconsin Ethics Commission. I present to you Judge Higginbotham.
Hello, everyone. Welcome, and I'm so glad that you're here today. Wisconsin Supreme Court elections are the most important judicial elections that we have. And it's imperative that you approach the voting booth as somebody who is knowledgeable about the issues that are before us, but also more importantly about how the candidates got to where they are. My topic today is to talk about big money or dark money in campaigns financial contributions to candidates. And this is a topic I suspect that many people are very familiar with, especially coming out of the recent presidential and congressional elections. But I want to start off by asking the question, what is dark money and what role does it play in politics and especially in judicial elections? And I'm just going to read a definition by Wikipedia, and there are a number of other definitions that are pretty much similar. Wikipedia says, in politics, particularly the politics of the United States, dark money refers to spending to influence elections, public policy, and political discourse where the source of the money is not disclosed to the public. And that last piece is very, very important. Wisconsin, for many, many years, did not have special interests contributing to judicial candidates at all levels, actually, of the judiciary. And it's only been, frankly, since about 2006, 2007, that has occurred. We've had a number of elections in the state early on, and I'm really referring to the time around the late 1990s and early 2000s, where there wasn't much in terms of special interest contributions. And you know, and I want to emphasize that the special interest contributions are made with the intent of trying to influence the candidate to essentially take a position that is consistent with the position that that special interest group wants to advocate. I ran for the Wisconsin Supreme Court in 2003, and I was taking a look at the record of that particular race. And while there were some contributions made to Pat Rogansack, who eventually ended up being justice on the Wisconsin Supreme Court, the level of contributions made in that particular race were not substantial. Not until when 2007, 2008 election did the numbers start to go up. Now, what kind of numbers are we talking about? Who are the organizations that provided the contributions? And I want to make sure everybody understands these are contributions that are entirely separate from the candidate. The candidate can raise money. There are rules and statutes that govern how they can raise money and how much contributors can give to each Supreme Court candidate. The current rule now is a person can contribute up to $20,000 to a Supreme Court justice candidate. Back in 2007, 2008, those numbers were much smaller. The contributions were not nearly as large as they are now, but it was interesting to note that especially around the race between then Justice Louis Butler and Michael Gableman, that the numbers started to go up. And the organizations that contributed in support of Michael Gableman were organizations such as the Wisconsin Manufacturers and Commerce, Wisconsin Conservation Voters, and so forth. These are organizations that had a conservative agenda. And it's important to note that early on in the special interest contributions, they were primarily from more conservative organizations in support of more conservative judicial candidates. That eventually changed over time, but in the early time when we saw special interests weighing in on these interests, it was principally conservative organizations. Now, this arose out of the American Chamber of Commerce back in the late 1900s, when there was an intent to pour money into judicial candidates who would support their conservative agenda. And it's a long-term plan that has been highly effective. In Wisconsin, as I indicated, that didn't really start to happen until 2007, 2008. And then the numbers started to dip for a little while. But then what we started to see after we saw the United States Supreme Court decision in 2010, Citizens United versus the Federal Election Commission, which stood for the proposition that money was speech and that it was unconstitutional to prevent organizations from spending as much as they wanted in elections. That's when you started to see a monstrous change in the amount of contributions that were being made, and not only in presidential and congressional elections and in governor elections, but also in judicial elections. And that's notable because Wisconsin still took a little bit to pick it up from there. But as we got later into the 2010s, the numbers really started to go up considerably. By the time the most recent judicial Wisconsin Supreme Court race was held between current Justice Janet Protasewicz and Dan Kelly, that race, $51 million were spent on that race, and a whole bit of that came from special interests. Excuse me. And it was from special interests on both sides. So no longer were conservative special interest groups being the primary contributors to judicial candidates. You also saw on the more liberal side, large contributions being made to judicial candidates. And this gets back to what I was saying about what dark money is. The intent is to try to influence the candidate and whatever decisions that they're made. And at the same time, they don't have to say who is contributing the money. This is a level of lack of transparency that a lot of people are very, very upset about, especially when it comes to judicial elections, because the historic sense is that judges are impartial. And in that impartiality lies at the center of our judiciary. That has changed. And now, if you even pay attention to the current race, then you're seeing that a lot of issues are being discussed that perhaps would not have been discussed 10 years ago when so much money was not at stake. Now, I'm going to talk a little bit more. I'm going to talk a little bit about what kind of issues have really pushed contributions. Not least among them is the issue of abortion. When the United States Supreme Court issued its decision, essentially wiping out Roe versus Wade, that was an incredible impetus for a tremendous amount of donations being given, including at the state level, to judicial candidates. And we saw that in the most recent case, again, with Justice Protasewicz against Dan Kelly. Justice Protasewicz ran, one of her biggest issues was abortion, and it was highly effective. Now, whether or not that is something that we wish to have in our judicial elections is a topic of great discussion and controversy. But it's almost like wishing that the barn door was closed after the horse ran out, because this is how we are now with Citizens United, with key issues coming out of the United States Supreme Court that affect our everyday lives. It's going to be very, very difficult to put the genie back into the bottle. In this election now that we're seeing in the current race, there is a projection that this race could garner $75 million in contributions, most of them coming from special interests. Now, frankly, as somebody who ran for the Wisconsin Supreme Court, I find that deeply troubling. Because it literally suggests that if you can buy a particular candidate's vote on a particular issue of interest to you, and if you take a look at a number of the decisions that are made by justices and judges throughout the country, there's a good argument that a purchase of a judge's vote is on the table. And this may be a controversial statement that I'm making. And that is not to say anything about the current candidates for the Wisconsin Supreme Court. But I think it's an issue that you as a voter have to pay very close attention to. Is your vote being bought? Are you going to be able to vote for somebody who is going to be impartial, who is going to be independent, who is going to think about the issues before them based on the record and based on the law, rather than based on the financial contributions that are made to that candidate throughout the campaign? Which brings me to a topic, which is recusal. In 2017, the Wisconsin Supreme Court had received a petition from 54 retired judges in Wisconsin to reduce the amount of contributions that could be made to a judge or justice before that judge or justice had to recuse themselves from a particular case. In a 5-2 vote, conservatives against the 2 liberal justices at that time, Justice Shirley Abrahamson and Ann Wash Bradley, the Supreme Court didn't even take up the petition and decided to not even address the issue on the basis of First Amendment rights to free speech. Highly controversial topic, but the issue here is right now, there doesn't seem to be a limit as to how much a judicial candidate can receive, including a Supreme Court justice, as to how much they can receive and whether or not they have to recuse themselves from that particular case. If that's not problematic to you, it's problematic to me, because this leads back to what I was just indicating, which is there is a suggestion here that a person can be bought. If they're sitting on the Supreme Court and they've received certain contributions from certain special interest groups, what is the implication here? Now, Justice Rebecca Bradley in 2017 found it offensive that issue was even raised as a possibility. But if we take a close look at the votes that the Supreme Court has made over the last 10 years, especially with cases involving some of these special interest groups, I suggest that is something that you may want to take a closer look at and determine for yourselves as to whether or not that is at play in Wisconsin. That's all I have right now. I really appreciate your attention. Just as I'm going to plug this, please pay attention to the money that is being spent in this race and who's making the contributions. And does a candidate feel as if they have to abide by whatever donor is giving them and what topics that they are interested in and being presented to the court? Thank you.
Thank you, Judge Higginbotham, for your thought-provoking comments. Now we are moving on to our final speaker, Jeff Mandel, who's General Counsel of Law Forward, a law firm founded in 2020 with a mission of protecting democracy and working to ensure fair elections. He has handled various high-profile cases before the Wisconsin Supreme Court involving redistricting, absentee ballot drop boxes, and separation of powers. He is a graduate of the University of Chicago Law School. He also served as a law clerk to the Honorable A. Raymond Randolph at the U.S. Court of Appeals for the D.C. Circuit. I present to you General Counsel Jeff Mandel.
Thanks, Marilyn, and thank you to the league for having me tonight. Let me, I'm gonna try to be fairly brief, but let me try to pick up and bring together what Rob and Paul spoke about. Right, Rob sort of previewed that one of the questions he was going to leave to me is how does who we choose in a Wisconsin Supreme Court election, or what the Wisconsin Supreme Court does, affect individual voters? And Paul spoke about why there's so much special interest money in our judicial elections these days. Seems to me these two questions are related. If there isn't so much effect on what is happening here in Wisconsin from the Supreme Court, we might not really expect individuals and organizations and industries around the country to be willing to sink so many millions of dollars into these races. I think that it's difficult to say right off the bat and clearly to any particular voter, this is how the Supreme Court's going to affect your life, because each of us makes our voting decisions based on our own perceived interests and priorities. But let me give you some examples, primarily ones related to democracy, of things the Wisconsin Supreme Court has done in just the last few years, or will likely do in the next couple of years, that I would suggest at least affect all people in Wisconsin. The Wisconsin Supreme Court has heard and decided several cases related to how our state legislative maps are structured and whether they will be gerrymandered to favor a particular political party or other interests. That's about whether our democracy works and who gets to be in our legislature and make our laws. The Wisconsin Supreme Court has heard a number of cases in recent years about voting rights and who gets to participate and how the process works to ensure that eligible voters are not excluded and that the person and candidate who gets the most votes actually wins the election. The Wisconsin Supreme Court has heard and will continue to hear cases about how the administrative state works in Wisconsin. I know that sounds really boring, but the question is, will our government be able to regulate conduct and make sure that there is a balance between various interests in our state so that we have clean air and clean water and public parks, that public education works, and that other public goods work for the public? Or will we allow the free market to take over to such an extent that those interests might be eclipsed? And the court acts, right? Rob said it's at the apex of the judiciary. I think that's right. The judiciary acts as the referee when we have disputes among other political actors, whether that is between the governor and the legislature, or it's between the legislature and local governments, or between county governments and municipal governments. We need that honest referee that makes sure that things work the way they're supposed to. And the last thing I want to mention in terms of how the Supreme Court affects voters is the court decides, is the final voice on what state law and our state constitution means. When there are questions of federal law, those can be appealed up to the US Supreme Court. But on questions of what the state law means and what our state constitution means, the Wisconsin Supreme Court gets the final word. And that can mean a great deal, including how much, if at all, do we want to import meaning to our state constitution? Do we want to see that as a document that really governs life here in Wisconsin? Or do we see it as sort of minor and unimportant because primarily we are governed by our federal constitution? That has for many, many years been sort of the thought process that the state constitution is not very important, it is not talked about. And one of the things that is changing in our legal culture is some of that. And so we could see our Wisconsin Supreme Court putting a greater emphasis on our state constitution, which protects additional rights and protects democracy to a greater extent than the federal constitution does. Just like I can't tell you exactly what issues are most important to each voter or to each of you, I also can't tell you exactly what's going to come before the Wisconsin Supreme Court in the next year or two, because the court has a tremendous amount of control over which cases it chooses to hear. But what I can do is give you a sampling of democracy cases that are working their way through the court system and that very well could be presented to the justices in the next year or two. So that could be coming before the court next year, or at the very least, that whoever wins this court election will probably have the chance to help decide whether the court hears the case. And then if so, what the court does with it. So let me identify a number of those. And these are really focused on ones that involve democracy. There are quite a few about election procedures and how our elections work. Should absentee ballots be discounted if there is a minor error made by the witness who signs for the voter? That's a question that is working its way. Briefing is complete in the Court of Appeals. A decision will come probably sometime in 2025, and that case could be appealed to the state Supreme Court. Whether voters with print disabilities have the right to mark and return their ballots electronically. That is a question that briefing is complete in the Court of Appeals and could work its way up to the Supreme Court. How to think about our separation of powers and the checks and balances that underlie our entire government in Wisconsin, given that the legislature passed a statute in 2018 after Governor Evers and Attorney General Call were elected, giving itself the right to intervene in any lawsuit and speak for the state. Traditionally, we thought the Attorney General was sort of the lawyer for the state. The legislature has given itself the right to show up in court anytime it wants and also say that it speaks for the state. And does that violate the separation of powers? There too, briefing is complete in the Court of Appeals and the case is likely working its way through the system. Is it legal to spoil an absentee ballot so that you can cast a new ballot? This is something that was traditionally done in Wisconsin for years and years and years. The idea is that you cast your absentee ballot in advance of Election Day generally, and maybe something happens in that final home stretch of the campaign that makes you change your mind or think about something differently. Can you go to the clerk's office and say, I'd like that absentee ballot? You don't really get it back, but you say, I'd like you to destroy that absentee ballot, and I'd like you to give me another one. I only get to vote once, but I've changed my mind and I want to do it a little bit differently. For decades, that was legal in Wisconsin. Starting a couple of years ago, that is now not legal. That was actually a decision by Judge Schimmel in his circuit court. And that case is in the Court of Appeals getting briefed right now. Does the Elections Commission have authority to delegate certain decisions to the administrator, who is the chief election officer in the state of Wisconsin, if the commissioners have the chance to review the decision the administrator makes? That is a case where briefing is underway in the Court of Appeals. There was an attempted purge of the Milwaukee County voter rolls. There was an effort right before the 2024 election to strip 150,000 registered voters from those rolls. That failed, but briefing is underway in the Court of Appeals about whether the rejection of that attempted purge was correct. Whether the Elections Commission has an obligation to require all registered voters to prove their citizenship. That case also lost in the circuit court shortly before the 2024 election, and briefing is underway in the Court of Appeals. Whether the fraudulent elector scheme to overturn the 2020 election results in Wisconsin violated Wisconsin criminal law. That case is proceeding in the trial courts. Whether municipalities with fewer than 10,000 residents are allowed by law in Wisconsin to hand count ballots instead of using electronic voting machines that everyone acknowledges are more accurate at counting large numbers of ballots with multiple races on them. That case is pending before the Elections Commission. Whether a voter has the right to return their absentee ballot on election day to their polling place, or instead must take it to the clerk's office at their city, village, or town hall. This is another one of these things that for decades in Wisconsin was never questioned. You could take your absentee ballot to your polling place and turn it in. But there are some municipalities in recent years that have said, no, 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 that's improper. You can only bring it back to the clerk's office. That is an issue pending before the Elections Commission. Let me flag a few that are technically before the Supreme Court right now, but it's not yet clear if those things will be decided this term, or if whoever gets elected will get to participate. First is one that almost certainly will go to the new court after this election, and that is what consequences former Supreme Court Justice Michael Gableman might face for ethical violations alleged during his leadership of a legislative investigation into the 2020 election. That case is in an evidentiary phase. There will be a hearing this summer, and then ultimately the Supreme Court decides all lawyer ethics and accountability issues. Whether the Wisconsin Constitution protects the right to abortion, that case is been accepted by the Supreme Court to be heard, but there's not a briefing schedule yet, and so it's seeming increasingly unlikely it will be decided before the new justice joins the court. Proper standards for how an administrative agency makes decisions about granting or denying permits to businesses or zoning changes. That case has been decided by the Court of Appeals, and the Supreme Court is deciding whether it will take it up. Who gets to go to court, and whether plaintiffs must show some kind of unique individualized injury to go to court, or whether you can complain about a government decision that hurts all the people in your neighborhood or all the people in your community equally. Is that something that you can take to court? That case was decided by the Court of Appeals, and the Supreme Court is deciding whether it should take it up. And then the last one that I will flag is whether the constraints that 2011 Wisconsin Act 10 put on public sector unions violate the Wisconsin Constitution. That is a case that Act 10 was struck down. In full disclosure, I am one of the lawyers in that case. We won that case in the Dane County Circuit Court. It is up on appeal, and there is a pending petition for the Supreme Court to hear it, take it up quickly, and potentially hear it even this term before the new justice takes their seat, but it's not clear yet whether that's going to happen. So there's a whole variety of things just in the democracy area that I think, your mileage may vary on which of those is most exciting or most important to you. But I think that all of those could very well affect people's lives and help illustrate the stakes, not only for individual voters, but also help illustrate why there is so much money pouring into these elections.
Thank you, Jeff Mandel. All of our presenters presented such thought-provoking, informative information. And those of you who are listening have been sending questions to us, and I am sifting and winnowing a few and putting them together. And a number of you are concerned about what authority does the state have to regulate money in politics, especially the Supreme Court races that this forum focuses on. Let me read two questions and then ask our presenters to weigh in. Is it not possible to pass a law requiring that donations to PACs be identified down to the level of individual persons, and those amounts be publicly available? In a segue to this, can individual states set up their campaign finance laws as the state sees fit? Or are all efforts to have campaign finance laws with donation limits and disclosure requirements eliminated or not allowed because of Citizens United? So do either of our three speakers wish to weigh in on what authority the state may have to regulate contributions to its judicial races?
I mean, I could start, and maybe Paul also has something to say, because as someone who serves on the Ethics Commission, they directly regulate campaign finance in the state. So answering the second question first, individual states cannot just set up campaign finance laws as they see fit. The US Supreme Court's decisions in this area are based on the First Amendment, and those First Amendment principles apply to both federal and state elections. And it's not just Citizens United, but a line of cases that traces back even decades before then. So the states are bound by the significant limitations that those US Supreme Court precedents impose. Now, they do leave still some room for certain regulations. So what are things that are off the table? I mean, basically, the state couldn't decide that it just wants to place a cap on outside spending, right? Those kinds of expenditure restrictions the court has said the US Supreme Court has said are invalid. The US Supreme Court has given somewhat greater latitude for states and the federal government to require disclosure. And so that first question about whether there could be a law that required more extensive PAC donations down to the individual who donates to the PAC, the answer is that there probably is some leeway to strengthen our disclosure laws. And there are some states that do have stronger disclosure laws than Wisconsin does. There's a little bit of an open question even here. In recent years, the US Supreme Court has become a little bit more skeptical even of disclosure laws, but that is an area where there's still some room for regulation. Another place where there's some room for regulation that I'll just flag briefly is public financing. We briefly had public financing for judicial elections in Wisconsin. We eliminated it, but public financing is still something that is an allowable form of regulation.
Yeah, and I'll just weigh in at this point. Rob, you're totally correct. You know, the federal courts have put pretty strong restrictions regarding disclosure. There has been an effort in Wisconsin in the past to try to require disclosure down to the individual who is making the contribution. But that really, that's been taken off the table in Wisconsin. And at this point, I sincerely doubt that there's any promise or any hope for that type of regulation. And in terms of public finance, correct, that was a law briefly in Wisconsin, but the conservatives took that off the table, and that's no longer the case. The Wisconsin Ethics Commission does regulate campaign finance. But we still have to work within the confines of, in particular, the federal law. And so to the extent that we regulate campaign finance, it's really more in response to the decisions that have been made by the courts, as well as any statutory limitations.
One of our listeners pointed out that the Wisconsin Democracy Campaign does a great job of following the money. I know they have a website here in Wisconsin. And does anyone want to comment on their?
I even have one of their articles where, in fact, that was actually serving as part of the basis for some of my discussion. And I'm really very grateful for the fact that they went all the way back to 1999 to take a look at what the expenditures were, and they did a really great job. And that was their work clearly showed that there really was virtually no special interest contributions up until the race that I participated in with Pat Rugensack and Ed Brunner. But still, the contributions that were made were really like $27,200 independent expenditures. And for the next number of races, independent expenditures played a very small role. But the Wisconsin Democracy did a really great job at developing these stats and in showing that as we got into the late teens, then it's really started to explode. And it's very indicative of how much special interest has now controlled a lot of these elections. When you take a look at how much the special interests have donated as opposed to the candidates, it's so lopsided that you're beginning to wonder, who's actually running. Is it the special interest or is it the candidate? So but their work has been very helpful, I think, in highlighting the changes in our campaign finance.
Thank you for your comments on that. We have a question. Should Wisconsin reinstate the impartial justice law, which was a campaign finance law that applied to the Supreme Court? Professor, can you?
Unless Paul, if you want to jump in on that one.
Well, it was there, but it was the conservatives who eliminated it. And as long as they're in control, in particular of the state legislature, there's not going to be a lot that can be done. And that's the quick answer to that.
One of our listeners asked, does being an expert in a particular field, such as medicine or computers, considered to be an advantage or a disadvantage for an aspiring justice?
Rob, turn to you.
Well, I think having some type of substantive expertise can be very helpful when the court hears those types of cases. We have on the Wisconsin Supreme Court right now a fair bit of criminal law expertise. As I said, a number of the current justices have served as prosecutors. And so I imagine that is helpful when they consider those cases, to have a high level of familiarity going in. There are, say, some technically complicated class action disputes or something like that. And if you were a practicing lawyer who handled those kinds of cases, that may give you an advantage. So, being a state Supreme Court justice, that is really a generalist's job. The range of cases that they can take is significant. Because it's a multi-member court, it's actually helpful if you have justices who may have different substantive experiences that they're able to bring to bear. So I'm not sure how to answer the question beyond that.
I tell you, one of the things I really enjoyed being on the court, both on the trial court, on the Court of Appeals, is we had to learn very quickly about a lot of things. And some of the cases required us to drill down more deeply. For me, that was fun because I like to learn. But it is helpful if you have judges or justices from various backgrounds, because then they bring that to the table, especially if you're working on a panel, because I think it really informs the decision-making in a very positive way.
A question for Judge Higginbotham. If spending on a judicial election is done by a non-candidate, be it a company, a union, or some very wealthy person buying TV ads in support of a particular candidate, how does the candidate learn who was behind the ads? Does dark money make it anonymous?
Well, in general, yes, although it's really very interesting. When I ran for the Supreme Court, candidates could not communicate with these dark money groups. The dark money groups had to campaign on their own and could not collaborate with the candidate. Under those circumstances, the candidate can't know who who the donors are. My understanding now is that that kind of communication can happen. Now, whether or not it extends to whether a candidate can learn of a particular donor's name, I actually don't know that answer. I don't know what the current law is on that topic, unless Jeff and Rob, you have any sense about what that is. I think the answer is no.
And one of our listeners would like to know if our presenters could suggest any constitutional amendments that would improve the function of the Wisconsin Supreme Court. I guess implicit is a feeling that perhaps it could use some improvement, or the lower courts in Wisconsin.
I'm going to start a discussion group on that topic next week. That's such a hard question to answer because it entails such a deep drill into the problems, and it really requires the bringing together of great minds who can iron that out. And I'm not even pretending I'm one of them.
I too am probably not one of those great minds, and I'm very aware that I have not been on one of the courts, and therefore, you know, have a limited view from the outside. I do have suggestions for how the court could function, the courts could function better. I have some suggestions of how we could change procedure, but I would suggest that none of them need to be in the Constitution. That these are things that we could solve through much simpler rules and other things like that. And in fact, I would suggest that what we've seen in Wisconsin over the last decade or so is too much cramming things into the Constitution that don't need to be in the Constitution.
Yeah, I would agree with that.
I don't have much to add on that one. It's a very hard question. It's one that I actually would love to sit down and think about more, but off the top of my head, I'm probably not going to have the great amendment idea for you.
I believe we've finished up the questions from or do we have any additional questions? We have some wonderful people here in this studio who are keeping an eye on the chats and monitoring any of our viewers who want to pose additional questions.
There's a question from Kathleen Fullen. Do you want me to just say it?
Yes.
Okay.
Can they hear you?
I can read it in the chat.
All right.
So Kathleen Fullen had asked, in a recent appearance, former Justice Janine Geske opined that it was highly unlikely that the Wisconsin Supreme Court would implement an effective recusal rule because so many of the current justices have received significant contributions. Has it been suggested that the Supreme Court could implement recusal rules for itself based on campaign contributions made after adoption of the rule? I realize that it would take a long time for such a rule to be effective for sitting justices, but it would have a positive effect on future campaigns.
So let me sum up that question for some who might not have heard it. The way I understand it, and the presenters will correct me if I'm wrong, is one of our listeners would like to know if our Wisconsin Supreme Court justices could implement recusal rules that would take effect in response to large contributions, which the public might view as impacting on their ability to be fair and impartial.
I mean, there probably are ways that we could strengthen our recusal rules. Our recusal rules and some of our other judicial ethics rules actually were weakened in the last 10 or 15 years. And so they could probably at least be dialed up to where they were before. Wisconsin is sort of unusual in having in its code of judicial ethics a provision that basically affirmatively tells judges and justices that they don't need to recuse based on campaign contributions, and that they shouldn't presume that because they received money from an interested party that requires recusal. There are some states that do have the opposite presumption, and if there's money received above a certain amount, then recusal is required. So I think that it would be at least theoretically open to us to adopt that rule. I think the person who asked the question is right that there might be a practical issue with that. The sitting justices have campaigned and received funds without having that understanding, and so it might have implications for them that they're uncomfortable with. And the last thing I'll say, and maybe others will want to weigh in as well. A year or two ago, shortly after Justice Protasiewicz took the court, and there were questions about whether she should recuse from the redistricting case that was brought. Together with a co-author, I actually published a quite lengthy explainer about Wisconsin's judicial recusal requirements. And so if anyone really wants to dive deeper into this, if you Google, you could probably Google explainer judicial recusal in Wisconsin and beyond, and you'll probably find what's a 40+ page document that I wrote about judicial recusal.
One thing I will point out, and Rob, I'm looking forward to taking a look at that, is Wisconsin has one of the weakest judicial recusal rules in the country. And the changes that were recommended in 2017 would have made it stronger. But as I indicated, the justices, the conservative justices on the court at that time, wouldn't even take up the petition. So right now, my sense is that Wisconsin continues to have very weak judicial recusal rules when it comes to especially campaign finance. Perhaps with the change in the composition of the court, we might see a possibility of stronger rules. I just don't know.
We might. Let me actually suggest that this question triggers for me a possible answer to the last question about constitutional amendments that could make things better. I think one of the challenges for the justices, to be fair, is that if they recuse themselves, the court is then shorthanded. And there is a line of precedent that the justices sometimes cite about how they have a duty to hear cases. Right. And so one potential improvement that might make things better and enable recusal more readily would be if we had a system for someone else to step in or some way to choose people to substitute into the Supreme Court to hear those cases, so that the court was not shorthanded or even disabled in instances where there were one or more justices who needed to recuse.
That topic's been bandied around for some time. I know when I was on the Court of Appeals, there was some serious discussion about that. It didn't go anywhere. The question is, how would that person be chosen? From what level of court would that person be chosen? None of these questions were anywhere close to being answered.
One of our listeners has asked whether the Supreme Court is still the final judge of ethics of Supreme Court justices.
Yes, absolutely. And that is a problem because when allegations were made that Justice David Prosser had put his hands around Justice Anwash Bradley, there were serious questions about how could this body, who is the final arbiter of ethics, even examine this incident. And but that has not been dealt with. And right now, the court has a final word on ethics violations.
The one small caveat is if the violation rises to the level of being a potential federal due process violation, in which case that could go up to the U.S. Supreme Court. But those are few and far between.
Yeah, thanks, Rob.
What our listeners are interested as they perhaps meet or are in forums with the current candidates for the Wisconsin Supreme Court. What kind of questions should they ask of the candidates?
Well, how long do we have? really. I mean, for any, Rob laid out, I think, a good outline of the kind of qualities you want in a justice. And I think some of the questions should go to that. What is your experience in the judiciary? How do you stand on making decisions based on what a particular donor is advocating? I mean, there's all sorts of kind of questions, and I think we could spend a whole nother seminar on this. And I'm not being very helpful, but my apologies.
I think if someone has been a judge, as the current candidates have, or even if they've haven't, you can ask this of lawyers. When have you decided a case or taken something on voluntarily that disagrees with your political inclinations? And tell us about that. What is the best case that was decided? The best decision you can look at that someone else made that legally best, that disagrees with your personal politics? What's the worst case that you can think of that agrees with the worst reasoned case that agrees with your politics, and explain why? I mean, I think part of what we're trying to get at is understanding how people approach some of these decisions, and what we can expect from some of the things Rob talked about at the beginning about integrity and intellectual honesty.
Right. When I was on the Court of Appeals, I was in District 4, and one of the things that all of the judges in that district felt very strongly about was parking our politics at the door. And I personally recall sitting on cases and voting in a way that was absolutely contrary to how I personally felt about it. But that is what the law required, and that is how we made the decision. When on the Supreme Court, they can tell you what the law is or not, and nobody else is looking at them. So you're going to want to know, can they park their politics at the door and make the decisions based on the record and based on the rule of law? I think that's excellent inquiry.
I would also just note that a piece of what the Supreme Court does that we don't talk about very much is they manage the entire judicial system.
Right.
And so another interesting question for someone who's trying to get on is about sort of what they think should change within the Wisconsin judiciary, or what we do really well, how we do something really well that's different from other states, or thinking about that management role and the court's function in overseeing our lower courts and our entire legal profession, I think is something that gets almost no attention in these elections, but is quite important.
There's been talk by the presenters of what's been happening in other states and how, when it comes to recusal, Wisconsin doesn't have what our presenters would hope, some of the things they see in other states. So one of our listeners wondered, is there a particular state that you would hold up as an example of a good way to handle recusals?
I don't have an answer to that.
I wish I did off the top of my head. It's possible, and it's been a while since I wrote that thing on judicial recusal in Wisconsin and beyond. I'm sure that there were some other states that I discussed there, and off the top of my head, I just don't have a particular model in mind. I know that there are at least some other states that have recusal laws that are stronger than ours in at least some respects.
One of our listeners, and it has been in the news of late, is interested in what were the circumstances that the presenters know that prompted Judge Hagedorn's recusal from the Act 10 case.
I can speak to that.
I bet you can.
Well, let me say a couple of things. Justice Hagedorn recused from the Act 10 case, and this happened just last week. It was both surprising and unsurprising. The surprising piece was that no party to the case had filed a motion or asked Justice Hagedorn to recuse. The unsurprising piece is that Justice Hagedorn has a long and deep history with Act 10. He was the chief legal counsel in Governor Walker's office and therefore was presumably heavily involved in drafting, refining, vetting, and ultimately approving Act 10. And then there were cases around that time in the early years of Act 10 challenging Act 10, and he was, as he wrote in his recusal decision, involved in leading the defense of the law. And so what he wrote in his order was that having reviewed the filings in the case so far, it was clear to him that it raised issues in which he had previously been involved and that he should not decide the case. I don't want to, and so I think that there's something, let me say it this way. I think there is something important about what Justice Hagedorn did, because recusal should not require the parties to ask the court. Recusal is an ethical obligation for each justice to raise on their own if each judge or justice, if they know that they cannot or that people would not reasonably expect that they could decide a case fairly. So I think there's something laudable here, and yet at the same time, I don't think we need to go overboard in congratulating a lawyer or a judge for meeting their ethical obligations. We expect that of everyone in our profession every day.
And Jeff, I think I'm going to touch on this very, very quickly. And Jeff, you made some excellent points. I can speak to Justice Hagedorn from personal experience in working with him when he was on the Court of Appeals and I was on District 4 Court of Appeals. I have found him, even though he and I disagree a great deal on a number of things. One thing that I really found working with him is there is a strong sense of ethics that there are some people who are really surprised by it because he often votes with the conservative majority or now conservative minority. But at his core, that is the kind of person he is. And I will give him credit for that. I applauded him when I read that.
Our final question is, one of our listeners wanted the presenters to comment on a story that Elon Musk was giving money to one of the candidates in the Wisconsin election.
That's a story I've heard. I haven't seen anything that verifies it.
I know that Mr. Musk endorsed on his social media network one of the candidates. I don't know if he has given any money or not.
All right. As we wind up this informative and thought-provoking forum, I direct your attention, listeners, to the Dane County League's website, and specifically the resource guide, which a number of league volunteers have put together, which provides additional information on today's topic and the Wisconsin Supreme Court. It can be found at League of Women Voters DaneCounty.org /forum/WI-Supreme.
It was put in the chat.
Oh,
The link is in the chat.
All right, thank you. I apologize. It's in the chat. Let me just remind our listeners that you're invited to attend another league webinar, this time on responsible gun laws and policies for Wisconsin on March 6th. On Saturday, April 26th, you're invited to attend a luncheon where the speaker, Mary Beth Collins of the UW Center for Community and Nonprofit Studies, will present on civic health in Wisconsin. Further information on these and other events, as well as opportunities to volunteer and donate to the league, you can go to the website to find that. I want to convey a heartfelt appreciation to today's presenters, Professor Yablon, Judge Higginbotham, and General Counsel Mandel for their presentations. All three of them invested their time and a great deal of effort in pulling together information to help us voters make informed decisions. Please remember the primary is February 18th and the spring election is April 1st, 2025. Yes, April 1st, and that is not a joke. Thank you for attending and participating in tonight's program.
And thank you to the League of Women Voters for putting this on. Your hard work is deeply appreciated.